1.2 is published in the business papers, and they relate to 3 different applications. And they are the order which we'll consider them. Firstly, 1.1, a DA for 15 to 35 Warnervale Road and 95 to 171 Virginia Road, Warnervale, relating to a subdivision. Item 1.2, which is a modification application for 69 to 71 Avoca Drive, Avoca Beach, which is a cinema. And lastly, item 2.2, a modification application for 2 to 6 Fairport Avenue and 46 to 48 Ocean Parade, the entrance. The second part is the public following the public meeting for those 3 items. The second part is a separate electronic meeting to consider determination of a DA at 22 Clairvaux Road, Warnborough, to be considered by the same panel. That's known as item 2.1. I'll just check if you can unmute yourselves, panel, just to verify any conflicts of interest for those 3 items on the public meeting. I understand. Sorry, Tessa, if you can go on mute again. Lindsay, sorry. Any no
conflict of interest, Jason.
No conflicts from Lindsay Day, Kevin Hoffman.
No conflicts.
And Robert Carter.
Yeah, no conflict.
Okay, thank you. There is one non-pecuniary declaration of interest related to item 2.2 that I need to make. And that's the last item at 2 to 6 Fairport Avenue and 46 to 48 Ocean Parade, the entrance, as the planner for that matter is, for the applicant, sorry, is a friend. And this may constitute a reasonably perceived conflict of interest. We don't have a business relationship. And just to be clear, I've taken no part in deliberations to date on that item and will take no part in subsequent deliberations or the decision. As it's the last item, we will run through the 2 items before it in this public meeting, and then when we get to that last item I've declared an interest for, I will leave the meeting for that item, and Kevin Hoffman will sit in as chair for that item. As there's 3 panel members for that item without me, that constitutes a quorum for that item. So the next part, for the next few minutes, I'm just going to run over the rules and procedures for the meeting, which applies to all items. Council staff have registered all interested parties who wish to address us, and this is being facilitated via an electronic Teams meeting, sorry. As in normal procedures, we will hear from registered people who want to address us, and the panel may have questions of the speakers. The whole meeting is being webcast, as I understand, and voice recorded. And the voice recording will be uploaded on Council's website, along with our decisions in the coming days. Next, I'm just going to read what I understand to be the registered speakers for the first 2 items. When Kevin Hoffman chairs the item I'm not involved in, he'll go through the speakers for that last item. But for the first 2 items, and part of the reason for doing this is just to make sure that people who are registered to speak hear themselves. And if anyone thinks they've registered to speak or have a burning desire to address us, let me know and unmute yourself before we move on, because they will be the order of speakers that we invite up. So for the first item in Warnervale, the subdivision, there's 2 representatives speaking for the applicant, as I understand, Stephanie Van Dizzle and Jason Yeo. And for the second item at Avoca Beach, I have 3 speaking, as I understand, for the proposal. I'm not sure if they're applicant representatives or members of the public, but Norman Hunter, Karen Zuschner, and Elaine Norling, sorry. I might just check and pause here for a second to see if there's anyone listening who thinks they've registered to speak and didn't hear their name or wants to address us. If you can just unmute yourselves and let me know. Otherwise, we'll move on. No, that's good. That registration process worked well. So I'll just go through a few more procedures for the meeting. I can let you know as a panel of 4 for these 3 items and 3 later, had a report from council staff and attachments related to the applications. Those have been made publicly available through council's website. We've also had briefings by council staff and some additional information related to some queries from the panel. And where those queries have led to some further written advice, that written advice will be published on the council's website as soon as practicable. Speakers have up to 3 minutes to speak. You'll be advised when you're approaching your time limit and asked to sum up. I'd ask that mobile phones be turned on silent and that speakers be heard in silence, and that, as people have been doing, just keep yourself on mute if you're able while you're not addressing us. It just cuts back on the background noise. Otherwise, there's to be no other recording of this meeting by voice or filming, as that requires prior permission of the panel, which hasn't been sought or given. A few more things, not long to go. Very importantly, there's to be no criticism, personal criticism especially directed at council staff, other speakers, the panel, or people who aren't here. Be aware this is a public meeting that is being recorded, and you're responsible for any comments you make, and those should not be slanderous. Also, don't seek to denigrate others in an attempt to win a perceived argument. It's also not a question and answer session, so any questions put to the panel will be taken as rhetorical and reflecting an issue of concern, as opposed to a question the panel will answer. Similarly, it's not a town hall debate, and as mentioned before, if you can refrain from interjecting or interrupting other speakers, that'll be appreciated. Once your speech or address to the panel has ended and any questions are exhausted from the panel, that will be the end of your verbal presentation to the panel. We ask and expect that courtesy and respect be shown throughout the meeting. People are entitled to their views, and these views should be respected, even if disagreed with. Nearly there, as mentioned, after hearing from all those registered to address us and any questions from the panel, the public meeting will close after those three items, and then the panel will sit and deliberate and make decisions for as long as it takes. The decisions, when they're arrived at, will include reasons, and both the decisions of the reasons will be published on the council's website along with the audio recording of the meeting. Decisions of the panel are by majority vote, with the chair having a casting vote if needed. Applications will be either approved, refused or deferred. It's possible the panel may make a different decision than recommended by council staff. If the matter is deferred, it's also possible the panel may subsequently determine the application by electronic means without another public meeting. So thanks for your patience with all of that. So we're ready to move on to the first item, which is at Warnerville Road, the subdivision. And so I'd ask, I'm not sure if Stephanie Van Dissel or Jason Yeo are wanting to address us or not. I should mention just before you do, if you are, and not just here to answer questions, we have received an updated memo from council staff about some refinements to conditions. I understand some of those have been in discussion with yourselves and some have been updated to correct errors or respond to some queries. So I'm just letting you know that. So if either Stephanie Van Dissel or Jason Yeo want to address us, now's the time, or let us know if you're here to answer questions.
So we don't have anything to add further to council's assessment report, and we're just here to answer questions if you had anything of us. I'm the town planner for the applicant, and Jason is the subdivision designer and senior civil engineer. Okay, great. And you don't have anyone here from your client, like? Not that I can see in the list. No. I'm not trying to catch you out. I just might have directed more to them, but we'll see how we go. Panel members, anyone like to start with any questions? If so, just unmute yourself and fire away.
No, I'm okay. Thanks, Jason.
Lindsay, I'm not sure we can hear you. You might tell, I'm not sure if Tess might need to unmute.
Yes.
Sorry about that. There we go.
We got it. Sorry. Yeah, I don't have any questions. We've covered a lot in the briefings and site inspections, etc. Thank you.
Thanks, Ms. Day. Mr.
Thank
Hoff.
you. If you're asking me, I've read all the reports and we've had the site inspection, well, a virtual site inspection, and I don't have any further questions given the amended conditions. Thank you.
Mr. Carter, any questions?
No, I'm fine, thank you.
Look, I've got a few, and part of it's just out of professional interest, but I'm not sure you'll be able to answer. That's why I was asking about your client. But do you know what the take-up rate's been in stage one? This is just out of a matter of interest.
I believe there's 100% take-up rate.
Yeah, so but in terms of dwellings per year, what sort of turnover is happening there?
Oh, I couldn't tell you. I don't know if Jason's on the line because I think he dialed in via phone. Jason, are you there?
Sorry, can you hear me?
Yes.
So the take-up rate's 100% at the moment. AB Jennings are selling some of the land as land only, and then they're building some of the dwellings themselves and selling it as house and land packages. But as of this stage, what's been built has been sold. I'm unsure of the turnover. Sorry.
No, that's fine. And in terms of the typology and demand, do you know anything about that? Again, this is more sort of professional curiosity about what's sort of turning over. This is a mix of larger lots with dwellings and smaller lots and sort of row housing. What seems to be has there been any change in demand, or is there anything you're able to tell us about the demand profile?
Yeah, so stages 2A and 2B, which is what's built and what you see at the moment, is mainly 450 square metre lots and larger, because it's in the R2 zone. So at this stage, they're mainly the larger size lots. They've got some smaller dwellings in this proposed DA, also smaller lots, I should say, because it's in the R1 zone. So we know, not for this development, other developments around the area, the smaller lots are selling better just because they're more affordable. So AB Jennings is looking to do something similar.
And probably the last two questions from me. So on the smaller, like I get and understand and support the notion of providing a range of lot sizes, particularly in the R2 zone, smaller lots, larger lots, a bit of a range, helps with diversity housing, is still meeting the overall density targets of council. But with the smaller lots, I mean, one observation is I've noticed in some of the release areas that all that happens with smaller lots is you end up with the same sized houses jimmied and crammed into smaller lots with no landscaping or trees. So how does that issue of diversity, house size and affordability get managed from your end or at building stage? Is there anything you're able to say about that?
Look, generally, because AB Jennings are house builders as well, they sort of pick the products that they want to put on the blocks, as opposed to say a mum and dad coming along and picking a project home. Right. What AB Jennings tend to do is try and put a bit of variety in there with some what we call zero lot builds, where they'll build to the boundary and have an easement on the low side in some cases, or they'll try and mix it up by having, say, some 12-metre frontages and then some that are 13, some that are 13.5, and sort of vary the frontage size.
Right. And what percentage would they build themselves as opposed to sell to build?
It just depends on where their building team's up to, if they need more stock to be able to build on to keep their people employed and busy. Usually that's what governs, and also how things are selling in the market. Like at the moment on the coast in this area, generally house and land is selling better than just land, but sometimes that flips around. So yeah, it just varies.
And driven and keeping the team busy. And the last question that kind of is relevant to your application is the lot sizes. Again, I don't see so much of an issue, and I know the council staff are all happy with it with the R2 zone, but something that sort of I wasn't sure about and how it's best handled by either us or yourselves is the undersized lots, which are the majority of the lots in the R1 zone. The R1 zone allows residential flat buildings, but you've got lot sizes down to 350. Now, I know that's a form of higher density housing, but the issue I can potentially see is if I'm a land investor or purchaser, I buy a land at 350 square metres, has just recently been approved at that size, check the highest and best use and the permissible use as a residential flat building, and say, well, I've got a reasonable expectation to be able to get the highest and best use on this lot that's recently been subdivided in a zone that allows for flats, but they're too small. So how does that issue get managed?
Well, Jason, I'll jump in and answer that one.
Yeah.
I guess with this site, so we've got sort of two DCPs that control the development. You've got your standard DCP for subdivisions, but this site also has a site-specific DCP. And for the R1 zoning, it has a certain density requirement, and the expectation is that you do have these smaller lots in this specific area. I think what's happened is that the site-specific DCP, that takes precedent, and that's written into the DCP. But I'm not sure how well the DCP sort of, convey that message. So all I would say is in this case, because it has that site-specific DCP, it's very clear on the type of density and the housing typology for this area. So, I mean, I would hope, and I'm not an assessing officer, but if someone came in, in another zone, they would have to comply with the controls of the main subdivision DCP.
Right. So it just means if the minimum size for flats in this local government area is 700 square metres, you just have to potentially buy two lots, I guess. But is that happening? It's happening on the ground with these flat buildings that are permissible.
It's on this site, no, because at the moment they've only developed the R2 zone. But
Right.
no, look, I can't imagine that would happen.
Right. Okay. That's it for me. Unless there's any follow-up questions from other panel members from that discussion, we will move on. Kevin, you might be on mute. I think you just.
Have you seen the latest amendments to the conditions?
We have not, but I have briefly discussed those with the assessing officer this morning. So I assume that they are all okay.
Okay, so you've got nothing to add to them. Okay. Thank you.
So we saw the conditions that were put up in the agenda 2 days ago.
Yeah.
And we've seen those ones.
Okay. And the amended ones we just got?
We have not seen those.
But you discussed them with the council officer?
We have. Yeah, I don't know if we've discussed all of them. We had a few minor sort of anomalies that we tidied up with the assessing officer, but I'm not sure of any others.
Okay, thank you.
Anyone else before we wrap this one up? Don't have to, that's good. Okay, thanks Stephanie Van Dizzle and Jason Yeo, you're free to go. As mentioned, we do have updated conditions. I'll be very surprised if they don't reflect some of the discussions given the diligence of the officer involved. But we will consider those updated conditions at the end of this meeting and make a decision in due course. Thank you.
Thank you.
Thank you.
Through you, Mr. Chair. Through you,
Yeah.
Mr. Chair. Could Rob Carter, the community rep, turn his camera on, please? Because the panel members need to be visible during meetings. Thank you.
Okay, so the next item, 69 to 71 Avoca Drive, Avoca Beach, the modification to the cinema. As I mentioned, I've got Norman Hunter, Karen Zushner, Elaine Norling. Sorry, I'm not sure if you're with the applicant. I've got down here speaking for the proposal. As I said, I'm not sure if you're representing the applicant or members of the public supporting the proposal. But if you'd each like to take your turn and let us know where you sit in relation to the proposal, anything you'd like to say to us.
Hi, Jason. I'm just here with our consultant team. So basically, we're just here to answer any questions you have. But I also have Norman here and Beth, who are going to speak.
Oh, good. Okay. And just before, thanks. I wasn't sure if you're with the applicant or others. I assume maybe the applicant. But if you could just let us know the range of disciplines you've got in the room, then it lets us know if we've got any questions who to best direct them to.
Yeah, so we have Adam, our town planner, and we have our architect here. And online, we also have Philip Pollard, who is our view consultant.
Right. Okay. Great. Thanks. Okay, panel members, any questions? Oh, sorry, did you want to address us, or are you here for questions?
No, but Beth would like to address you, if that's okay.
Sure.
Yeah.
Thanks. I might just get Beth your name. I don't know if I've got that down.
Oh, hi, I'm Beth Hunter. So I'm married to Norman.
Oh, okay. Beth Hunter. Thanks. Sorry.
Yeah.
Got it.
So Norman's dad built the theatre. The business started in 1948. He built it in 1951, and Norman inherited it in 1983. So we're kind of long term. We're very community based, very community based. So lots of charity work, lots of fundraisers, we don't run much in the way of Hollywood films. We are very much about art house, but particularly in supporting Australian films. So in the last 2 weeks, we would have had 5 Australian films that have all received no funding, federal or state, but we support them, so we give them an audience. We also do a lot of live music, so over 150 this year, and we focus on original Australian music, which works very well. We also do tributes and classical and jazz and world music, but our passion is for original Australian music, and so our passion is actually to enrich and deliver our Australian culture to our Australian community, and particularly our local community. This building, we absolutely need this building to facilitate that.
Okay, thanks, Ms. Hunter. Anyone want to add any more comments before we move to questions?
There is a lady called Elaine Norling who is also registered to speak.
Yep, is she with us, Elaine Norling? If you're with us.
The microphone was on mute. Is she able to be unmuted?
I think you can unmute yourself. Elaine Norling, if you're listening, press the unmute button and we'll be all ears.
We were having some technical issues with Elaine previously when I was trying to do the test with her.
Right.
I don't know if that's been resolved. I don't.
You can talk by my phone.
Is it okay if she speaks on the telephone to you?
Yeah, sure, if we can hear her.
Okay, we'll put her on speakerphone. Just ringing now. Sorry for the delay.
Okay, go Elaine. Where's the
microphone? Online.
It's supposed to be.
Just a minute, Elaine.
Okay,
Okay, Elaine, off you go.
I'll possibly repeat some of the things that have already been said. But Evoca Theatre is so much more than
I think we lost your
Did
punch.
she just drop out?
I think so.
I think they've gone on mute.
Okay.
Keep going, Elaine.
I start again.
No, you're right. We heard it's
So
a
much more,
cultural hub.
we got so much more than something.
Entertainment both on the screen and on the stage, and it supports so many creatives of our society with world-class film, world-class performers, which are available most days of the week. Now, how special is that? Filmmakers often give Q&A sessions, adding to the experience. Musicians and performers love the venue as much as the audience appreciates their talents. Locals are proud of the place. Tourists often come from overseas and are amazed at what is on offer. Regulars even travel from as far away as Armidale, Newcastle and Sydney. As Beth said, it was established in 1948. The community of Evoca was only 400 at the time. Now this wonderful venue, this iconic venue in fact, reaches thousands of people in our region and broader. It is worthy of nurture and support. Thank you.
Thank you, Elaine.
Oh,
Thank you. Okay, so I assume no one else in the team has anything further to add, just answering questions, is that right?
No, just questions.
Great, thank you. Okay, I'll pass over to the panel. Any panel member want to kick off? Just unmute yourself if you've got any questions.
Well, we have amended draft conditions for this application too. Has the applicant seen them?
Yes.
You have. So you've got nothing to
Yes.
say about them.
No.
Okay, thank you.
Any other? No, okay, thanks, Rob. Just a question. So what's the intent with the building program? So you've demolished, is that right? You've demolished part of the, so when's the, what's the program?
Correct. We've demolished the house that was on site to activate our DA, and then we're waiting for this section 4.56 to come through to work out what our plan will be moving forward.
Right, okay, you've got to work out all the finance and all the rest of it, so it's not immediate.
Correct.
Right, okay. And that demolition, because you haven't paid that money that's required under the VPA to the council for contribution towards car parking and so on, that's prior to CC.
No, that
demolition. So the demolition wasn't a CC, is that right? Or that was exempt or something, was it?
yes, correct. We put an amendment in to have it exempt.
Okay, and that's why it didn't activate that contribution to the council. Okay, no, that's clear. Yeah, as Mr. Hoffman mentioned, there were some refinements to condition, but generally consistent with that attachment 7 in the business papers published. So thanks for all your attendance. We heard and understood the comments made in support. We don't have any registered speakers against it today. So as mentioned before, we'll take all those comments in consideration as well as all the information before us. So thanks. You're welcome to stay for the rest of the meeting, but that's the end of that item for us. No more questions is probably a good thing.
Thank you.
Thank you. And now for this public meeting, before we close the public meeting, go into the electronic determination. As mentioned up front, I'm declaring a non-pecuniary interest for item 2.2 in Fairport Avenue and Ocean Parade in the entrance. So I will exit the meeting and leave you in the capable hands of Kevin Hoffman. Thanks, everyone. Bye.
Bye.
Thank you, Jason. I see I'm listed as unknown user. I'm sorry, that hasn't been included. I'm Kevin Hoffman anyway, and taking over as chair with for this last matter, which is DA 1849/2005 and /B 2-6 Fairport Avenue and 46-48 Ocean Parade, the entrance. It's a residential flat building and demolition of existing structures, and this is an amended application to the original approval. Now, I have listed to speak a number of people. I'll read the names, just indicate your presence, please. Robin Parker, Kate Monaghan, Giovanni Carrillo, Aaron Gadiel, Janine Sugars, and Evan Pearson. Are you all here?
Yes.
Yes.
Yes. Oh, that's good. Well, I'll call this. Usually I like to hear the speakers against the proposal first and then hear from the applicant. And the panel members may have questions as a result of each speaker. We'll take you one at a time. I'll go Robin Parker first, if that's okay. Robin, you should give your name and your address for the record.
Thanks, Chair. Robin Parker, Unit 21, 50-54 Ocean Parade. It's referred to as the Harriet in some of the correspondence.
All right. And what did you wish to tell us?
The panel, a different panel, 3 years ago, previously requested further information to support the assertion that the original DA hadn't lapsed and that work had begun by way of demolition on the site. The burden of proof is now upon that applicant and they've failed. There's no such new information. There's not one photo, not one Google map, check stub or bank statement. Why not? Because it just doesn't exist. Instead, the only evidence that work had commenced is the same couple of invoices, which aren't receipts, noting that payment would be required when 50% of the demolition had commenced. These invoices don't include detailed information and are of limited or no evidentiary value. The opinions of Mills Oakley and DMPS regarding commencement of work are just repeating the assertions by the applicant and they don't include new evidence. Furthermore, none of the authors can attest to having viewed the site during the period concerned. In terms of photographic evidence, I can help the panel out. A property for sale that was sold on the 10th of December in advertising shows those houses in situ. That property was Unit 35, 38 to 42 Denning Street. Clearly, those houses were present and one submission last time was dismissed as saying he didn't buy that unit because those properties were there and he remembered seeing them. Mm-hmm. We support PJ Denellen's opinion that a construction certificate was required and necessary. No construction certificate was issued And furthermore, the liquidators say no works were in progress. That was also dismissed by lawyers as with a spurious argument that demolition must have occurred. Demolition has occurred, but it didn't occur in the date required. That doesn't address the timing of the demolition at all. We don't dispute that housing is not required, but this is a 56-unit, 6-storey plus communal roof development with a reduced GFR 11.7 metres higher than it is allowed by the current LEP. And that LEP was introduced to ensure that future growth was tempered, measured in size and scale, and particularly near the coastline. That's great insight and planning by the panel. Don't be persuaded by photographs of other apartment buildings in your meeting papers. There are buildings built pre-2012. The majority aren't in streets affected by the LEP height changes. So furthermore, you know, it's not in the spirit of good planning and placemaking and development to allow such an overdevelopment as this. It's a massive overreach on today's standards. Letting that proceed when we know that the original DA had lapsed is really, we think, quite outrageous. Don't let them go ahead with this. Send them back to the drawing board and deliver a development that honours the principles of the current DA. That's all we're asking.
Hi, Robin, you've reached your 3-minute speaking time.
I've finished. I'm happy to answer any questions.
Well, I only have one quick comment. We're in receipt of legal advice, confidential legal advice from both the applicant's lawyer and the council's lawyer, which we will consider before we make a decision. Now, I take it other members who are going to speak will speak to the issues apart from the commencement issue in terms of the adverse effects on the locality or the site or their particular property. Did the panel members have any questions? I see the Honourable Robin Parker. I'm sorry, I didn't give you your correct title.
That's absolutely fine. I'm just a local member who's keen on the current LEP being observed by this planning panel, particularly as we're about to have a new council. Be terrible to throw that out, wouldn't it?
Okay, thank you. Panel members, any questions?
No, none from me. Just to say that the legal advice, as Kevin has said, will be fully considered at the end of the meeting, along with everything we've received in terms of the reports and so on. And thanks for voicing your opinion.
All right.
Thank you.
Thank you. I'll now go on to the next person I have listed, Kate Monaghan. Kathleen Monaghan, I see on the screen.
Yes, that's my official name, but I do go by Kate.
All right, and your address, please?
I'm in Unit 18 in 50 Ocean Parade, the Harriet building.
All right.
Next to the proposed development.
Yep, please go ahead.
Okay, well, following on from Robin's comments, the fact that a month was given and now we're now 3 years on past that initial month that the last LPP gave the developer, it seems quite strange that with no communication from the LPP or council in that 3-year period, last week we suddenly got a letter to say that there was another LPP meeting today. Part of all of the supplementary report, it was only made available to us last Friday. The confidential attachments that you're referring to, I'm assuming, are those legal documents that you've referred to. My question is, why haven't they been, put on public record? Because it does have a direct influence on the property development next to us. Council noted in that supplementary report that there were no submissions against the development back in 2009. Well, our building didn't exist then, so it's pretty hard to put anything in against that when we weren't even here. Previous points that were raised by residents of the Harriet were the actual height. In 2013, the height limit for the area was changed by council from 18 metres to 12. The DA for this property is now at 23.2 metres and as such is non-compliant with the Statement of Environment's effect. Council's response to that was non-compliant but justified. How can something so clearly different be justified? It's almost double what is allowed and over 30% the previous approved height limit of 18 metres. That's a substantial change and it has a huge effect on the shadowing effect onto our building and other neighbouring buildings to the proposed development. Also is the risk to the structural integrity of our building with construction on our boundary lines. With a double basement level to be dug out, on the original assessment report states that a dilapidation report was to be conducted at the applicant's expense prior to a construction certificate. Has that dilapidation report been done? If so, where is it? And then another concern was the increased road usage and lack of street parking available. Insufficient street parking, actual parking in the development for 56 units is a shortfall, even according to council's own regulations. It's 6 residents short and 2 visitor parking spaces short from council's own demands. And finally, almost 20 years have passed since the initial DA in 2005 was submitted. Yes, this amendment was done in 2020, but surely council and the LPP can recognise the fact that the current situation is vastly different to what it was 20 years ago. The council changes to the specifications were made for a reason, to produce better development for the entrance area. This lapsed and inappropriate DA should not be resurrected or deferred. I believe that it should be thrown out. So thank you for listening.
Thank you. Any questions from the panel?
No, thanks, Kate. Just a clarification on the dilapidation report. It's my understanding that a dilapidation report won't be undertaken until a construction certificate is issued, and a construction certificate hasn't yet been issued. So that's probably why that hasn't happened yet.
Okay. I thought that was one of the requests of the previous LPP, that a construction certificate was to be produced.
Well, if they had it, I suppose, but it hasn't been produced in the documents before us.
Okay, thank you.
Okay. All right, we can now go. I think another person appearing against the proposal is Janine Sugars. Are you present there, Janine?
Yes, I am. Can you hear me?
Yes. Could you give your address, please?
It's Unit 22.
Yeah.
Of the Harriet, next door to the neighbouring field.
Okay. Right. Now, would you go ahead and tell us what you want to say?
Okay.
Yes.
Everyone's covered pretty well much what I was going to say, but on the lapse date, I'll just commence with one of the most crucial receipts that on petition 34 of the DA's consent conditions, which would have provided the actual start date of physical commencement, was the licensed plumber's receipt to disconnect all services before demolition started. Now, this would have provided the actual start of the physical commencement. The council's report on page 11 of this supplementary report said that after searching their records, they were unable to find this dated certification, and that the council's drainage inspector did not carry out the inspection until the 22nd of July 2009, which is 1 month after the lapse date. Council also assumes that on December 23 on their report, page 18, that the construction company BFW's invoices didn't form part of the liquidator's report because they must have already been paid for works done on site. Now, this is incorrect. The invoices were directed to Beachview's property at Linfield, which was up for sale at the time, and a holder of charge of mortgage was put on those invoices. Now, the director of this address was also insolvent from early May onward, and therefore BFW Constructions were not authorised to commence work. Invoices produced by BFW cannot be relied upon as evidence. It's not normal practice that these invoices in question will be preferential payment treatment over Central Coast Council who did not get paid and did form part of the liquidated debtors report. It's also noted that a former director of this building site was added to these proceedings, which would make the deeds of this site be transferable, and the property was disclaimed by the liquidator on the 17th of August 2009. Thank you.
Okay. Questions from the panel? I don't have any on this.
No, thanks, Janine, for outlining that.
Thank you.
Okay. Well, thank you, Janine. Now, the other three speakers I have are in favour of the proposal. The first one would be Giovanni Carrillo.
I'm here, Chairman. Thank you. I was the planner that was responsible some years ago for the Statement of Environmental Effects, and I represent the applicant. We also have, before the panel today, we have Aaron Gadiel from Mills Oakley, and we have Evan Pearson from Candle Epperson Associates.
Right.
In turn, they'll speak to matters relevant to their areas of expertise. Insofar as it relates to my area of expertise, I won't deal with the demolition issue. Aaron is available and will speak to that after I speak, if that's all right, Mr. Chairman.
Yes, that's fine.
Thank you. But I will speak to some of the matters that were raised by the objectors before you today. In particular, matters were raised about building height, construction methodology, dilapidation, traffic and parking. In relation to those respective matters, we'll deal with construction and dilapidation first. By way of condition of consent, the draft conditions that have been put to the panel would have required a dilapidation report. That would be required as a precursor to the construction certificate. Of course, you can't obtain a construction certificate until you've got development consent. Given we don't have development consent, that's not possible. So such a thing would be prepared in the event that a consent is granted. There would be pointless doing it in advance of obtaining development consent.
Yes.
I hope that fully answers that question. With relation to height, it is largely the same as the approved development. There is a small increase of, I think, 1.23 metres in the location of one of the lift overruns. The number of lift overruns in the development has been changed. There were 4, I believe there's now 3. But Chair, would you mind? I'm having one of the objectors was shaking their head at me. I'd prefer to be allowed to speak without people shaking their heads, if that's okay.
Yes, if you don't mind.
Thank you. Thank you.
Thank you.
Fine now. So there's a small increase in height of 1.23 metres in the location of one of the lift overruns. That doesn't cause any impacts. In fact, it's also landscaped in the surrounding area around that lift overrun. The council officers support the variation to the approved height limit that is in the existing consent, and there is no additional impact as concluded by the report insofar as views, overshadowing or other scale or bulk impacts, which remain the same as the approved development. With respect to traffic and parking, there remain 72 parking spaces in total, I think, in the development, and 56 apartments are proposed. That is an increase from 45 apartments. The council's own technical experts have concurred that there is no adverse traffic or parking impact, and the amount of parking that has been provided is certainly adequate for the development. We also agree that I think the parking provision is sufficient for the development, and we concur with the officers' report. We also concur with the initial findings of the officers with relation to the commencement of the development, and but I'll leave to Aaron to speak about that in greater detail.
All right. I had a question. Would you like to comment on the council's statutory change of height, lowering the permissible height versus your continuation of the height limit of the existing consent?
Yes, we don't believe, and Aaron may speak to this in greater detail, but we don't believe they apply. The current consent that has been granted is being modified, and the previous controls under the former LEP remain the relevant controls for the purposes of this development application.
Okay. And just tell us a little more clearly why, when you're increasing the number of apartments from 45 to 56, and because you're taking out the lower basement, reducing the car parks by, what is it, 6 resident parking and 2 visitors. Just give us the logic behind that.
The logic of it is the development as it was approved was largely skewed towards oversized apartments. There were some, I think there were 45 apartments comprising 4 1-bedders, 16 2-bedders and 25 3-bedders. And as I understand it, the previously approved scheme had very large 3-bedroom apartments. Now this is more skewed towards a middle market rather than trying to promote an unaffordable product for this market. And so the 56 units comprises, I think, 1 studio, 9 1-bedders, 38 2-bedders. So the bulk is in the form of 2-bedroom apartments, which are more, I think, needed and affordable in this market. And there are only 8 3-bedroom apartments. So the emphasis is more upon 2-bedroom apartments rather than very large, oversized 3-bedroom apartments, many of which had private rooftop terraces and private swimming pools and the like. That's all been removed. And
so can I just ask a question?
Yes.
We know that for a 3-bedder, you usually require more car parks than you do for 1-bedders or bed sitters.
Yes.
Is there a calculation in there? Is there?
I believe I don't have it, and if you don't mind, Chair, I could seek your leave to look at the report, but I'm actually on the telephone from overseas at the moment, so I don't have the report at hand.
All right. Okay. Right. Any questions from the rest of the panel?
No, Kevin asked the one that I was going to ask, which is why was the basement deleted? I think that would perhaps an explanation for the people who have rejected as well as the panel. Just that simple question. What was
I think Evan Pearson might do that. But effectively, there is less of a need for as many parking spots. The previous consent was over provided in terms of car parking. It was well in excess of code. This is more, I suppose, it's slightly under, but there is been I suppose the positioning of the approved development was very large. It was very large units with an over provision of car parking. Well in excess of requirements. I have Evan Pearson, the architect for the project here.
Hello, my name is Evan Pearson. I'm representing Candelipus Associates. Thank you for the opportunity to address you. Look, the main, one of the very important reasons why that basement or those basement levels were significantly re-looked at was the fact of the water table, and construction in the water table, I think, is understood to be a very difficult, costly and inconvenient outcome for any building. So we re-looked at a lot of the geotechnical information that had been done and saw how we could refine the design. But essentially it's to try and lift it as much as possible out of that water table and the associated issues that you get with groundwater.
All right. Now listen, you came in so quickly.
In the report, it talks about the localised overland flow that goes through the site. So are you suggesting that by deleting that basement level, some of that overland flow across the site will be able to be better managed or differently managed than the original consent?
Look, I think they might be 2 different issues. The overland flow path, which we did refine and work with Council's engineering team to come up with the current flood design for the area. So that is a refinement from as we've taken on board. But the groundwater is a separate issue of, obviously there's an aquifer that sits under and near the sea level, and that building adjacent to the ocean has those associated issues. So that was perhaps seen as a secondary, as a separate issue to the overland flow.
All right. Sorry, Mr. Pearson, you've come up on the screen finally, or I found you out of the 3 that are running. You came in so quickly, I didn't hear your name or your address or which company you represent.
Sorry, Chair. My name's Evan Pearson. I'm representing the architecture firm Candelipus Associates. We're the architects for the project.
Ah, okay. Sorry. Thank you for that. Mr. Carrillo, had you finished what you wanted to say?
I have, Chair. If I can hand over to Aaron Gadiel, if with your permission.
All right. Well, since we're hearing from Mr. Pearson now, can you finish what you wanted to talk about, Mr. Pearson?
Look, I'm here just to answer any questions that the panel might have. I think obviously that this has been discussed previously, but I'm mainly here just to answer. I can briefly run through some of the architectural merits of the project, if that's something that the panel might like to hear.
Well, look, when we looked at the plans, it seems the building covers the same footprint and it's very close to the same height. But there is, of course, a consideration that is it substantially the same design as the original when there's a lot of changes to the interior layout coming from increasing the number of units, and there's been a lot of let's say removal of the basement car park and other things. Just talk to us about why it's really the same development or a similar development sufficient for the panel to give consent.
Chair,
Could I just add from Kevin's request is that there is additional, the floor space ratio has increased for the modification as opposed to what was approved. So if you could also just add that into your response to the panel, please.
Yeah, look, I think
we'll come back to you, Mr. Carrillo.
Thank you.
I think, look, I might get Aaron to speak to some of those questions. I think that there are perhaps more legal. Can I just quickly note, though, that I think the floor space, the gross floor area is actually reduced from the original DA, so I don't believe it has increased. And can I also say that we still do have basement parking, it's just reduced a little. If you look at one of the architectural drawing sheets, you can see that we've provided a number of different options for more affordable and more flexible living. And if you calculate the apartments as we have, there's actually a very similar number. I think council, we've proposed a more flexible unit configuration with what's called dual key. So that allows either to be used as a 3-bedroom or a 1 and 2 bedroom. So if you actually look at that as a 3-bedroom unit, I think it's a very similar number of apartments. I think it's 47 on our calculation sheets versus 45 of the DA. But on the question of substantially the same, I think Aaron is probably better place to discuss that.
All right.
That's okay.
Any other questions from the panel to Mr. Pearson?
Yes, yes, Chair, I do. I just want to get just a very clear clarification around this development. So the original height in this area of the entrance was 18 metres. What is the actual height now, excluding the lift overruns? What is the actual height, excluding the lift overruns, that you're proposing at the moment?
Look, the lift overruns, I think you can see there's a top pergola structure there at, I'm just looking at the elevations that we've provided in as part of the application, and I think it does depend on where you strike the ground level, but if you look at one of those pergola structures at, let me just, apologies.
Maybe if I just clarify something which might assist Mr. Pearson as well. So my name's Aaron Gadiel. I'm Mills Oakley, the lawyer for the applicant, planning and environment lawyer. The 18-metre height limit under the controls that applied when the consent was approved was measured differently. It's not to the top of the building, it's to the top of the ceiling in the highest level of the building. Mm-hmm. So if you're to compare like for like, you need to be comparing the height of the ceiling in that building when you're considering the 18 metres. And as I understand it, the ceiling is in fact within the 18-metre height limit.
Oh, okay.
But the question, so I appreciate that, Aaron, but the question still remains: if you go by that original marker, what is it? What is the building height? So you're saying it's basically 18 at the top apartment ceiling level. You're saying it's within that 18 metres. What is then the distance from that? What is the overrun now of the lift from that point then? From the lift overruns, what is it from that 18-metre ceiling level you're referring to the top?
Look, unfortunately, I don't have those figures at hand, but if you look at our drawings, there's a very detailed overlay of the previous application and the proposed, and that's in red, the proposed or approved envelope, and then now the proposed is outlined. So it's very clear there, and in many cases it's a reduction in height. Sometimes there's an increase, but look, that's probably a more useful way to look at this in terms of height.
Evan, you keep on saying it's very clear, but you can't actually answer the question, but yet Giovanni actually made specific references to the heights. He knew exactly where the heights were. So I just want to, you're saying it's easy and clear, but you can't answer the question. Giovanni made clear reference to his heights in his discussion. I want to get some clarity around that, please.
Look, it's more difficult for me to then go and work from the ceiling heights and measure up. I don't have that information at hand because it requires me to go and look at my drawings, and unfortunately in this forum, what I can say is the comparison of the approved envelope versus the application before you today is clearly outlined in our drawings.
Yeah, I think I've seen that overlay with the marking in red. But Rob's trying to put a figure to it. Giovanni, did you have a figure?
I think Giovanni's just getting the plans.
The height increase over and above the previously approved scheme is 1.23 metres higher in the location of one of the lift overruns.
So you're below, you're suggesting you're 19.23 then?
No. It's higher than the approved scheme.
Yeah.
So it's not, the building wasn't at, I think it depends on how it's defined, as Mr. Gadiel was saying earlier, but by comparison to comparing like for like in the location of the lift overrun, it's 1.23 metres higher than the top of the lift overrun previously.
Because of course, under the controls that applied when the approved scheme was put in place, the building didn't stop at 18 metres. It still had facade and lift overruns going above that, as was permissible at the time. So you can see what was reflected and regarded as acceptable at the time just by looking at the approved drawings. And then you can see that there is this variation at one point against that of the 1.5 metres or thereabouts. And that's what the panel needs to focus on.
Mm-hmm. Okay. Any more questions of Mr. Carrillo or Mr. Pearson?
Not from me.
All right.
Thank you very much.
Robert?
No, I'm okay, thank you.
Okay, now we go to Mr. Gadiel. Mr. Gadiel, you represent the applicant and a law firm.
Well, that's right, yes. So I'm from Mills Oakley. I'm a specialist planning and environment lawyer, and I've been working with the applicant on this project for 5 years. So well familiar with it. So there's a couple of legal issues have come up which I need to address. So perhaps just starting from recency first, substantially the same was raised, and Evan indicated that he would defer to me on that. So I think the best way of demonstrating that substantially the same is met is by just referring to a leading case on this subject, which is called Davey Development and Leichhardt Council. It's a judgment by a judge of the Land and Environment Court, Justice Talbot, in 2007. Still a very relevant precedent. That development application.
Interestingly, we've been given a number of documents, your letters to us, and so on, that are publicly available, part of the agenda. But a point was made this morning in discussions that some of the case law that is quoted in your correspondence is very old and has probably been perhaps superseded in regard to substantial commencement, and is the development substantially or significantly the same? So it's just a point to say that 07 is a long time ago.
Well, Mills Oakley hasn't written any letters about substantially the same for this development. So that's probably analysis that's prepared by a non-lawyer, probably Giovanni rather than ourselves. This is the first time we've been asked to address it, but I did come prepared to address it. Can I say, in law, a precedent that has stood unchallenged for a longer period of time is more robust than a decision that was handed down last week, which could still be subject to appeal or criticism by other judges. So the fact that we have a 2007 decision by a judge that has not been criticised in any relevant way in any decision since is in fact speak to its testimony as a good authority and a precedent that is should be abided by. So in law, the older precedents that are not then subsequently criticised and the many judgments that could have criticised them since then have far more weight. And that's why this 2007 judgment is very relevant. The facts of that matter, just to deal with it, it was a 1970s development consent for a 7-storey residential flat building with 2 levels of parking. The number of units was changed from 42 to 30, a 29% variation, and the unit mix throughout the building was changed. The number of residential floors was reduced by 1, and the internal layout of individual rooms was changed. And the height of the main parapet was increased by 400 millimetres, with an architectural element arising above that for a further 500 millimetres. And the car parking layout was entirely different, and a lift overrun was removed. So quite analogous to the current situation. And in that decision, Justice Talbot held that the substantially the same test was maintained. If we want to jump to the most recent leading decision on substantially the same, that is Realise Architecture by the Chief Judge of the Land and Environment Court. And it confirms the substantially the same test is an incredibly very flexible test that is judged by the consent authority, and if the matter is appealed, the Land and Environment Court on appeal. It allows flexibility as to how the consent authority approaches it, but certainly it's not inconsistent at all in the most recent decision making with earlier approaches, which focus on things like the bulk and scale. So you can ask yourself the question, is there material difference in the way the building will be perceived in terms of bulk and scale and its impacts on the surrounding community? And if your answer to that is no, there is no material difference, then it's open to you to conclude the development is substantially the same. That's one way of doing it. Another way of doing it is just to quantitatively look at it and say it's more or less the same height. It's a slight reduction in floor space ratio. It's generally the same dimensions, and that's also a legitimate way under the traditional and up-to-date case law to deal with substantially the same. I probably should move on, because I'm aware of time, I should move on to the issue of physical commencement. There's been some focus on receipts, but I'd like just to share my screen with you if I can. We actually have a document prepared by a registered surveyor that confirms that demolition was underway when the consent was otherwise due to lapse. So what I'm sharing with you right now is the plan of consolidation. So there was a requirement under the consent that the lots be consolidated. That was implemented. And in fact, this plan of consolidation was prepared. The plan of consolidation is a date of survey down here in the bottom left-hand corner is the 19th of June 2009. That's the lapse date of the consent. And what that confirms...
That's the 3-minute timer.
Right,
yeah.
well, it's an important issue that I need to respond on.
Just a minute. Panel's happy to continue to hear Mr. Gadia. Yes?
For another 3 minutes, yes, that's fine.
Okay, another 3 minutes.
Noted.
Thank you.
Thank you. So, so this is a plan prepared by a registered surveyor. So the consent was due to lapse on 19th of June 2009, unless it was physically commenced beforehand. And this plan prepared by a registered surveyor confirms in relation to the subject site that it was under demolition. Those words appear there, under demolition. So in fact, it confirms, as is other documents confirm, that demolition was actually underway at the lapse date. Now, that's, of course, so we've got that confirmation from a registered surveyor. That's better than photos or people's memories or accounts. You can't get much better than that. In terms of receipts, what we have is 2 payments that were sought by the builder. The builder got underway on the some point after the 3rd of June when they were given their initial payment, their upfront payment of $2,000, or they invoiced for their upfront payment of $2,450. And then a further period later, on the 12th of June, they then invoiced for the 50% of the 50% of the amount owing. The reason you have 2 different payments is that's the amount of money you pay up front to get the builder going, and then once 50% of the demolition work is complete, then you have to pay for that work before they'll do the other 50% of the demolition work. So that's how we know there's 2 very clear, right on the moment, contemporaneous sets of documents which tell us that the demolition work was underway and well underway before the 19th of June. It doesn't matter that it may not have been finished on that date. Very small amounts of demolition work are capable of and are regarded by the courts as physically commencing a development. In fact, activity as small as pegging out, placing pegs in the ground to start or indicate future construction works have been held by the Court of Appeal to physically commence development. There, of course, was no requirement for a construction certificate to physically commence the development. Case law consistently has confirmed that. Sharp and Hunters Hill, Benedict Industries, Smith and Wyong Council, all cases that make it clear that no construction certificate is required for physical commencement. We have in September 2009 confirmation from the council that it had had regard to all the case law, which would have included the case law that goes to compliance with conditions of consent, and that letter confirmed that the officers at the time had done their due diligence and confirmed that there was the consent had physically commenced. So whilst not every record of the council's activities in 2009 is available, which is not surprising, we do have a letter contemporaneously prepared in that era where an officer has confirmed that they've undertaken their due diligence and written and put in their name in writing saying that the development consent has indeed physically commenced.
So that goes to the issue of estoppel, does it?
Well, yes, it does, in the sense that if the council and the panel is an agent of the council at the moment, if the council were to resile from its previous representations, that would raise serious legal issues for the council and would certainly be a matter that would result in court proceedings involving the council after such a decision was made.
Okay.
But at the end of the day, you have to make a decision and the facts are here before you, which allow you to make the same decision that has already been made, which is in fact the consent was physically commenced and is therefore capable of modification.
Okay.
The third issue.
Any questions from the panel?
Oh, sorry, there's just the third issue that you raised earlier, a legal issue, which was the relevance of the 18-metre versus the current 12-metre height control. So we've talked about how they're measured in different ways. The current 12-metre height control is measured to the top of the building. The 18 metres was measured to the top of the ceiling. But the other thing just to focus on is that whilst you can note and take into consideration there's a current height control of 12, it has really no material relevance in the context of a building that is already approved much beyond that height. In that sense, you would give the existing control very little weight because you can't undo the approval that is already there. And if you refuse the modification application, all we are left with is the opportunity to build the building as it was approved, which is a suboptimal outcome in planning terms compared to the modified building.
Chair.
Thank you. Are you just about finished, Mr. Goodell?
I have finished, thank you.
All right, thank you. Questions from the panel?
None from me.
All right. Rob, questions from you?
I'm okay, thanks, Chair.
Okay. Well, thank you, both those for the development and those against. As you would know from the opening address at the start of the meeting, the panel will resolve into confidential mode to give consideration to the three matters before us, including this one. And also there's one more item that was listed for electronic determination anyway. So I can close the meeting at this point, which is 3:20 p.m. Thank you for your attendance. And as has been foreshadowed, the panel's decision will probably make a decision tonight, I think, and it will be published by the council shortly after. So thank you all.
There is a question for someone waiting to have the hand up. I don't know if you can see them.
No, I can't see them. Who are they?
Honourable Robin Parker, Chair.
Rowie Parker. Now, whoever that is was not a listed person?
Yes, she is. Yeah, she's spoken already. It's just a matter of whether you would like to hear more questions from her.
Oh, the Honourable Robin Parker. Right. Well, panel, what do you want to do? I think if we hear from her, we then need to give the applicant another chance to respond.
I would agree with that, and I don't know that it's necessary or appropriate for more questions and answers to continue.
All right, Robert?
Yes, I think.
I put a comment in the chat. That's fine. We hadn't seen the survey report until now, so we weren't able to comment or respond on it as objectors.
Okay.
Well,
Thank you,
just in brief reply to that, Mr. Chairman, very brief, is that that survey report was provided to the council.
Right.
Sorry. That survey report was provided to the council in 2022, so it's certainly not new information from the council's perspective.
Okay. Thank you. All right. Well, I think I'll close the meeting at this point and go into private session. Thank you all for your attendance.
Thank you, Chairman.
Thank you.
Thank you.
Thank you, Chair.
You.